Topic 10 is opinion and expert evidence. In evidence law, the starting point is that witnesses cannot give opinions. Their role is to tell the court what they actually observed, things they saw, heard, or felt. For example, they might say the car was moving quickly, but they cannot conclude the driver was negligent. That's for the judge or jury to decide basically. There are limited exceptions for lay witnesses. If an opinion is really just shorthand for ordinary observation, courts allow it. So, if a witness says someone looked up or it was dark, that's acceptable because it's the kind of impression any ordinary person could form. Expert evidence is treated differently. Under Section 79, if a person has specialized knowledge, whether from study, training, or experience, they can give opinions to assist the court. The key point is that the knowledge must be beyond what the judge or jury would ordinarily know. Courts also require expert evidence to be reliable and clearly reasoned. Experts must not overstep their expertise, and they need to explain how they reached their conclusions. If their opinion is too prejudicial or confusing compared to its value, the court can exclude it under Section 135. Several cases shape this area. In Clark v. Ryan, the High Court set limits on how far experts can go. In H.G. v. the Queen, the court warned that experts should not give opinions on the ultimate issue, like guilt or innocence. Finally, in Dasreef v. Hawchar, the High Court made clear that courts require strict proof that expertise is relevant and reliable. The overall aim is fairness or justice. Courts want to avoid unreliable or speculative expert testimony that could unfairly sway a jury. Expert evidence is admitted only when it is genuinely needed to assist the court, and it must remain within the limits of proper expertise. Thank you for watching. See you in the next lesson.